Good morning. Mark Brewer of Goodman Acker on behalf of the Michigan Senate and Senate Majority Leader Senator Winnie Brinks. Council asked about why there's never been a dispute like this before the courts in Michigan. It's because until this legislature, the legislature obeyed the Constitution and presented bills. And we document that history extensively in our briefing. It can be found in the House journals going back decades. And under the theory of the House, apropos of Judge Murray's question, a bill would never have to be presented. They insist there's no deadline, that this duty is completely unenforceable, and it's simply up to the legislature to decide. That would cause chaos and other problems in addition to infringing on the governor's veto power. It would be a violation of the separation of powers between the branches. It would also interrupt the checks and balances system that we have so carefully created. It would inject an entirely new procedure into the legislative process, that you pass the bills, but then at the whim of a legislative leader, they can decide at any time, maybe never, to present the bills to the governor. That's a prescription for chaos in the legislative process. But that's what the House asks you to sanction. Now, I think it's important to remember the facts here in this case. On January 8th, the day the House convened, they presented over a dozen bills that morning alone before the House convened, which had been passed in the prior session, consistent with past practice and with the legislature's understanding of what this constitutional duty means. The legislature convened at noon, and they continued to present bills passed by the previous legislature, except for these 9. We don't know why, but again, consistent with their practice, until the Speaker ordered these bills not to be presented, every other bill passed in the previous legislature.
Were these other bills that you're talking about, were they, maybe I misunderstood it. I thought that the bills that were continued to be presented on that day was before the new legislature was sworn in. Is that not accurate?
No, Your Honor. In our appendix, and I have a copy of it here, and this is drawn from the legislative record, so we're not submitting new evidence here. There were, it looks like, just eyeballing it, a couple dozen submitted before noon when the legislature convened, and then there were, by our count, several dozen submitted after noon.
Noon is after the new legislature is sworn in.
After the legislature is sworn in. And we have an entire list, a couple pages. The only ones that are missing are these 9. So the legislature, again, continuing its prior practice, was acknowledging that it has the obligation to present these. Indeed, Judge Koropkin, the language of Section 4, Article 4, Section 33 that you raised contemplates that there could be presentation of bills and action by the governor after the legislature adjourns. I mean, literally, as we detailed in our brief, under the current setup in the state capitol, the clerk could walk these bills down the hall to the governor's office. That's how ministerial, that's how clerical this whole process is. The Court of Claims set this deadline so that bills could be presented in time for the governor to consider them so they could take effect. That was part of her remedial authority that she set that. They complained, well, that's not set forth in the Constitution. No, but the court was in an extraordinary position trying to remedy a constitutional violation. The legislature, the House in this case, has a duty to present these bills. They have failed. And so we have turned to the courts for a remedy for that unconstitutional conduct. And we're asking, again, either for an order of mandamus or what has come to be called a reparative injunction to restore the status quo, to put the Senate and, frankly, the rest of the citizens of this state in the place they would have been had the legislature done its duty on January 8th, like it did with every other bill that morning, except for these 9.